I'm Roman Viere. I'm the president of the Greater Austin Development Association, and I've been a board member of the NBOA for about 5 years now. Actually, my father was a founding member of the NBOA way back, so I do have some qualifications. I'm not sure if I have enough, but let you judge that a little bit later. Today we have some fantastic speakers that are going to join us today. We're going to start off with Rebecca Levine from the Sheriff's Office, and then we'll move over to Emily Bloom-Carlin from the Preservation Compact and CIC, and she will talk to us a little bit about the emergency rental assistance, and then we'll engage with the attorneys that we have and let us know where we are, and we'll actually start at a very base level of how we got to where we are and how things are going to move forward. Reason we're going to start with the sheriff, which I would normally put that at the end, is she's just got a short window to share with us today. So I really want to give her an opportunity to give us an update of what's going on. And then we'll wrap it up. If there's some questions, please put it in the chat. I've got Mick on here that's going to be monitoring it for me, and he might jump in. His name may actually show up as Maggie Glasser, but it's Mick that's on her profile today. So without further adu, Becky Levine from the Sheriff's Office, I'd like to introduce you. Could you just give us a quick 2 seconds about you and your role there at the Sheriff's Office?
Sure. Thanks for having me. I'm really glad to be here. The sheriff has really been committed to staying in good touch with the housing provider community. So glad I was able to join. I'm sorry I can only be here for the first part of your meeting today. I'm Becky Levin. I'm the Executive Director of Public Policy at the Sheriff's Office. So while I won't be able to provide any kind of detailed information on what's happening on the operational side, what I would love to do today is get some insight into any top of mind questions that you all may have with the lifting of the moratorium and what it means for the sheriff's operations going forward. Essentially, when it comes to the lifting of the moratorium, even though the governor's executive order has expired, that absence of an executive order doesn't provide us with great direction about what things should look like this week. So today, things in the sheriff's office don't look appreciably different from what they did last week. Our understanding is that the Office of the Chief Judge will be issuing a general administrative order providing some additional guidance. And so we are eagerly looking forward to that so that we can get our staff trained on any new processes or procedures and really be reflecting what things should look like now. I will say I did want to comment. One thing that we know about is that we still have a lot of pre-COVID evictions out there. At the beginning of the period of time when we were able to enforce pre-COVID evictions, there are about 1,300 in the queue. We've only been able to enforce about half of those. For the other half, we're waiting for the housing providers to file that verification form that indicates that rental assistance has not been received and is not expected. So for anyone who's still waiting to have your pre-COVID evictions enforced, please get us that form. We'll put them on the calendar. If you have pre-COVID evictions in the queue, but they're no longer necessary, if you could just cancel those orders or let our office know. We are, in terms of our workforce, we are obviously committed to meeting all of our statutory obligations in terms of serving summons and enforcing evictions. But the more that we can kind of clear the decks of anything that's sitting out there that actually isn't necessary, the better we'll be able to plan for our workforce needs going forward.
Thank you, Becky. Let's go back to the verification form that you're asking to be filled out. As some people on this call may or may not know, they've been required for quite some time. Where can we find that form?
Yeah, so if you go to the sheriff's website, which is cookcountysheriff.org, on the front page, in the left-hand column, you'll see a link to eviction updates. If you click on that, it'll be the first thing you find on that. Also, if you're aware of colleagues, especially smaller housing providers, that verification form is available in Spanish and Polish as well. So we really want to make sure it's getting out there to everyone.
Okay. And of these 627 cases, I think you said, that are pre-COVID cases, do you guys have any grasp or an assumption of how many of those are cases that may be resolved that just haven't been canceled, or are you assuming that they're all real active cases that
we don't really know. We think it's probably a combination of both. Probably some housing providers who simply haven't known to file that verification form with us, or maybe, someone who, real small housing provider who just hasn't kept up on the various permutations of what's been going on over the course of the last 18 months. We also think there are some among that 600 some that really are no longer necessary. For example, we have had evictions where our deputies have gone out to enforce the eviction so the housing provider files the verification form indicating that they haven't received rental assistance, they don't think rental assistance is coming, the eviction is still necessary. Again, this is an order that was issued before COVID. Our deputies have gone out to enforce the eviction, and in more than one case found that the tenant had died months earlier. And so, those are things where if we can, get them cleared from the list too, those are housing providers who could have taken possession months earlier than they did.
Okay, and then so where we're sitting right now, so you are doing forcible evictions on the pre-COVID cases at this time?
Yes, absolutely.
Okay, and now, with the evictions that do occur, if you arrive at a forcible, you find that there's a COVID case in the unit, how do you guys handle that?
Yeah, there are two things for, if anyone hasn't had many forcibles happening during the last 18 months, there are two things to be aware of that are somewhat different or kind of tweaks on processes that have always been in place. One is that if someone in the home has COVID, we will delay enforcement of that eviction for 2 weeks. There is not a significant onus of, providing documentation of having COVID. We need to be protecting the health and safety of our deputies. I think if that were to happen multiple times, we go out to enforce the eviction, someone has COVID, we come back 2 weeks later, we come back 2 weeks later. At some point, we'll require documentation, but just, initially, we'll err on the side of protecting everyone's health and safety. The other thing to be aware of, and obviously court processes and communication are imperfect even in the best of times. I think things have just gotten messier. And so our anecdotal information, we don't have hard numbers to back this up, but the sense of the deputies is that more and more when they've gone out to enforce evictions, it's more likely than in pre-COVID times that the tenant will say something like, oh, I have a court date tomorrow, or, I have a motion that's pending and it's being heard next week. And so under those circumstances, we will verify that, but we will hold off on enforcing the eviction. So just something to be aware of if you're hearing that from your side as well.
And, one of the questions that popped up in the chat, which I think everybody's really curious about, is there was been reported on numerous news outlets that there would be a tsunami of eviction filings once the moratorium was lifted. Have we seen a tsunami of filings?
We have not, and this is the question that I would love to know the answer to as well, what we really think is going to happen. At the moment, I keep saying I'm cautiously optimistic that we are getting as many tenants and housing providers as possible connected to rental assistance so that housing providers can be made whole, or as much as possible given the stressors of the pandemic. In the month of August and September, there were about 3,200 filings, which is fewer than in quote unquote normal times. So I'm hoping that bodes well for there not being a tsunami, but time will tell. I think the next month or so is going to really be a good indication of what we can actually expect.
When do we think the sheriff's office is going to have a better idea on the direction from, I know this is a really hard question, but when we can get better direction from the judges and enforcement and everything, and structurally how that's all going to be moving forward?
If anyone has the secret to predicting the judicial side of things, I would love to know that. And there was a direct message to me with more of a question about rental assistance. And when Emily comes on, she'll be able to better answer questions about rental assistance than I can.
Okay. And there was in from Aaron Zimmerman. He's asking, how quickly can claims for health and safety for evictions be processed? In these situations, is it more expeditious or is it in line with the non-payment of rents? So how quickly can claims for health and safety for evictions be processed? I think that's probably more of the attorneys. Yeah, I'll keep that in the back burner.
I was also going to say we don't really know. The emergency evictions process has been very important during the moratorium, right? And so we don't have a good handle on starting this week how much that process will be used compared to in pre-COVID times.
If the housing provider has received rental assistance, does it mean that they cannot file for an eviction? Then we'll bring that up with the attorneys as well, Syed. So, all right, Becky, I think you've covered many of the questions that we are really kind of looking for answers on. Is there anybody else that the attorneys want to jump in? They have any questions for the sheriff while they have their ear? No. The declaration for the 5-day, we'll cover that with the attorneys as well. Okay, Becky, if you want to hang on for a little bit, we may jump back to you if you need to run. We do appreciate your time today.
Yeah, I can stick around for about 10 more minutes. I'll also put my contact information in the chat, and everyone, please feel free to contact me. What I would suggest, the sort of routine matters that you typically contact our civil process staff for, please continue to go to them. They'll be able to get things resolved more in real time. What would be really helpful and what I'm really eager to help with is if you're experiencing the same sort of issue over and over, if there's a process, a systems issue, even if that's not on the sheriff's side, if it's sort of where the sheriff's office intersects with other parts of the process, please feel free to reach out to me so we can see if we can get those issues resolved.
Thank you, Becky. And I just want to point out that the NBOA, we did reach out to the sheriff's office well before COVID ever started. We've developed this relationship with Becky and the sheriff's office. I want to say, was it like September of 2019 was the first time we all sat down, and we've been working on this, and we've been very thankful for you working with us and keeping the line of communication open, even when we weren't in a pandemic.
Yeah, we actually met in February of 2020. It
Oh,
was
oh, geez.
one of the, yeah, it just squeezed it in barely under the wire before we stopped meeting in person.
Right. Yeah. But we were thankful for the meeting, and thank you for keeping that line of communication open.
Yeah, and just the sheriff does really remain committed. I mean, he continues to state that, you know, unlike when he really made some bold moves during the mortgage foreclosure crisis, he recognizes that in this circumstance, you know, there are no good guys and bad guys. This is a virus that's affected us all, and he really does want to make sure that you know, you all are supported. The housing that you provide is central to the stability, you know, the fabric of communities.
Thank you. We do appreciate that. So we're going to transition now to the rental assistance side of this. We're going to turn over to Emily Bloom-Carlin from the Preservation Compact and CIC, one of our favorite entities. They've been great supporters of the NBOA and housing provider community. Welcome, Emily.
Hey everyone, as Roman said, my name is Emily Bloom-Carlin and I'm a program officer at the Preservation Compact. And many of you are familiar with this already, but for those who aren't, the Compact is a policy collaborative focused on preserving affordable housing. And like Roman said, we're housed at Community Investment Corporation, which is a nonprofit CDFI lender. And so over the past year, we've been tracking the state, county, and city emergency rental assistance programs. So Roman and Mike asked me to come and give a quick update on what programs are available now and what programs are coming soon. So first off, there are still opportunities to access emergency rental assistance in the city, Cook County, and elsewhere in the state. And this is true even if you've received assistance in previous rounds. And so I'm going to give a quick overview of what's open and what's coming soon. And I'll also put a link to our website in the chat. So at this website, we have sort of up-to-date program information, links to where you can fill out the applications, phone numbers to call for assistance, a guide to checking your application status, and a lot more. So anyway, if your building is in the city of Chicago, you can still apply for assistance through one of several sort of city delegate agencies. And again, all of those are listed on the website along with the phone number to call to get started. You can also apply for rental assistance through All Chicago, which is administering the Illinois Department of Human Services rental assistance program in the Chicago area. So tenants or housing providers can initiate an application and you can apply for both programs. So the only limit is that you can only accept assistance from one program, but you can apply for both and just accept whichever assistance comes in first. And so if your building is in suburban Cook County, as of yesterday, Cook County reopened their emergency rental assistance application. So they're accepting applications from now until October 29th. And again, either a tenant or a housing provider can start the application. And later this fall, there's even more. The Illinois Housing Development Authority and city are also launching new additional application rounds. And so I just want to emphasize that the great news is that these programs are for everyone. They aren't just for new applicants. So if you've never applied, great, you still have an opportunity. And if you applied in the past, but your tenant is still eligible and still behind on their rent, this is also for you. And these programs can cover the full outstanding amount or close to the full outstanding amount. Again, even if you've received funds on behalf of the tenant in the past. So for folks who haven't applied, the assistance can cover up to 18 months of arrearages total. And in like in previous rounds, the agencies really want to pay the housing provider directly. So in most cases, you can expect the payment to come directly to you if your application is approved. However, if you decide not to apply, tenants are able to apply on their own to some of these programs. Anyway, that's just my very, very quick overview. Like I said, all of this information and more is on our Unified Rental Assistance website, which I'll put into the chat again. And of course, happy to answer questions or clarify any additional details. So I see a couple of questions in the chat. And so I can sort of respond to the first one from Lawrence, which is how can a housing provider collect rental assistance if the tenant does not cooperate? And unfortunately, in this case, there are federal regulations from the Treasury Department that state that both the tenant and the house, that a tenant has to participate in all applications. So if your tenant is outright refusing, there's no way for you to sort of go it alone on these applications, unfortunately. Again, this is federal guidance. I think the local agencies, when we've spoken to them, have sort of recognized that this is a real issue that providers are facing, but their hands are just really tied. I do think there are some really good resources. For example, the Cook County Legal Aid for Housing and Debt program works both with tenants and with landlords and housing providers, and they can advise your tenant, on the benefits of why they might want to apply. And same with the City of Chicago delegate agencies. They can connect with your tenant and really try and make it clear to them what the consequences are of not applying and what the benefits really are of complying with the application process and sort of completing their application. So I hope that's helpful. Unfortunately, I never have good news when folks ask that question. So here's another question. I've received assistance from the state or city, but now the tenant has no ability to pay rent and are still affected by COVID. Is there rental assistance available to them? Yes. So that's what all of these programs that are currently open can do. So if your tenant still is affected by COVID, and so that COVID impact can be pretty broad. So that could be that they're unemployed, they still have reduced hours, they're facing childcare issues. Maybe they have underlying health conditions that prevent them from working because they're at higher risk of COVID, and a number of other issues. If they're still behind on rent, you can apply for additional assistance to cover that existing arrearage. So yes, absolutely. Check out the links on that website, apply for any program that serves your jurisdiction. And like I said, the agencies don't have any rule against you applying for multiple programs. You can apply for as many as you want. The only rule is that when you are approved, you can only choose to accept assistance from one of those programs. And that isn't just all on you either. If you apply for multiple programs, IDA and the other agencies also have sort of a backstop database that makes sure that people aren't going to be double paid. So let's see, is there any resource for landlords to receive rental assistance and still evict the tenant? So I think that might be, so the questions about eviction are more for the attorneys, so they can answer it later. I'm not an attorney, so I can't really provide any guidance on that. So let's see, someone asks, I have tenants applying and they don't currently owe rent, are they eligible? So that's an interesting question. I think it would depend a little bit on sort of why they're applying. Is it that they think that they're going to have an issue paying rent this month or next month? Do they have a new COVID impact? For example, did they get sick? Did they have to take time off work? I think in some cases, these sort of really specific questions are actually a great option to call either the City of Chicago's hotline to ask them like, hey, what's going on? Can you tell me if this person could be eligible or not? Or the state of Illinois' hotline, and I can put both of those numbers into the chat. Those are both also on the website. And so I think, yeah, for something like that, it's worth just calling and asking. I've actually heard recently that folks are getting through the hotlines pretty quickly, so it's not like you'll be on hold for, 10 minutes even. Let's see. Okay, so you have a couple, some people have tenants who don't have a COVID impact but need rental assistance. And these people have been denied by IDA and ERAP. So there are some rental assistance funds that are sort of existing out there pre-COVID. Those are usually through homeless service providers or through the Department of Family and Supportive Services. I can put some links into the chat on those as well. Your tenant may qualify for those just depending on the reason for their arrearage and sort of what's going on. But so there are some other funds out there and available. Let's see.
So I see the one that talks about having people approved yet they have not received payments. Do you want to talk about the rollout on the state, county, and city level on the ERP?
Yeah, definitely. And I'd be curious, Lori, if you put the specific agency into the chat that those tenants have been approved for that you haven't received payment for yet, that would be helpful for me too, because that's something that we have been talking to all of these agencies about too, is sort of their timeline and getting out. So, the bigger context here is that as much as it might not seem like it, the programs in Illinois have really been outperforming most of the other programs in the country. They're in the top 5 in getting rental assistance out there, which really says something about what's going on in the rest of the country. But so IDA, that's the statewide program, they are getting very close to the 90% approved and dispersed mark for their sort of tenant or for their housing provider-led application that happened sort of at the beginning of the summer. They've been processing all of those applications and going through the cure process. They're also about part of the way through the tenant-led application round. So if a tenant applied independently, they're also processing those applications right now. So Cook County also in their first round, they're again sort of close to that 90% mark, if not beyond it. They really have done a really good job in getting funds out the door quickly. And so I anticipate if you're in Cook County and you have properties and tenants who are eligible, that applying for this new round of rental assistance for Cook County should also move pretty quickly. The city of Chicago has been a little bit slower, but I believe that as of September 30th, they hit around the 65% dispersed mark, which was sort of a specific goal that most sort of agencies administering these programs were trying to hit. So is that helpful? I know
that is.
Generally we often ask the agencies like, hey, can you give us a ballpark for how long each individual application is going to take to process? And the answer is always no. So if you have an application that comes in, all of the documents are there from the beginning. A lot of times we're seeing a turnaround of 3 weeks. But again, if there are any complications, if the tenant uploads a document incorrectly or there's some confusion, again, it can take a little bit longer.
Okay. Well, so, we only have so much time to cover that part, and we got to move to the next portion of it. But Emily, I do appreciate your information. If you want to throw your email in the chat, so if people have specific questions, maybe they can reach out to you.
Absolutely. Very happy to.
Thank you. I appreciate it so much. So I'm going to transition now to the actual legal part of it and filing the evictions. And before we get into that, I think I'd be remiss if I didn't mention, there are some people on this Zoom that may not necessarily be housing providers or people who are supportive of the housing provider community. And we want to get out the fact that housing providers don't go into business with the desire to evict tenants. That's not what we do. It's not a business plan that works for anybody. This is always a last resort sort of thing. And, if we've gotten to the point where we're trying to evict a tenant, it's because all other means have broken down of communicating and trying to work things out. And when we get to these points, it's never a pleasant situation for anybody. Housing provider who, this is their job. This is how they earn a living, most of us. And because, this is how we earn a living, we have to do what we can to preserve our assets. So when we get to this point, we reach out to our attorney. And on this call, we have two fantastic attorneys that have supported NBOA, have been great sounding boards for everything that we've been going through. We have Michael Zink and Rob Kahn. I'm going to start off with Mike. Mike, so just we got into COVID, and then the city decides to hit us with the 30, 60, 90, 120 day notice for raising rents or termination of leases. So that's the amount of notice we need to give to our tenants. So do you want to just start off with, where we are on how we attack giving notice to tenants, even before a non-payment issue, more of a raise of rent and possibly we're terminating their lease for whatever reason.
Yeah, absolutely. Thanks, Roman. Thanks again for having me. It's always fun to be with you. And certainly I put my information in the chat, and Rob did too. So please feel free to reach out to us, because I know we're not going to get everything answered in the next 30, 45 minutes. But basically what you're talking about is the fair notice ordinance that was passed by the city last year. For those who don't know, it essentially what used to be a simple 30-day notice for a month tenant is no longer, or at least in most cases is no longer. So basically the city has set up this incremental steps of different kind of notices. So if a tenant has lived in the property for 6 months or less, then you can give them a 30-day notice. If it's between 6 months and 3 years, you have to give them a 60-day notice. And if they've lived there longer than 3 years, then it's a 120-day notice, which is 4 months. That applies not only to terminating month-to-month tenants, but as Roman mentioned, it also applies to notifying people that you're not going to be renewing the lease. It also applies to any notices of rent increases as well. So how does that play right now? It really hasn't come much into play in the last year. For a while, you couldn't even issue those notices under the governor's moratorium. But basically now I've had quite a few people asking about them, primarily situations where people are trying to sell their properties And of course, it's very difficult to sell properties if you have a tenant in it, especially if it's a single family home. So what the notices essentially have to do is, at least in this month of October, if you were to give them a 120-day notice, it would have to be given sometime during the month of October if you wanted to have a termination date of the end of February 2022. Essentially, you have to go 120 days out and go to the end of that month. So right now we stand, if any 120-day notices go out, it goes all the way to the end of February. It's important that you talk to an attorney before you do much of anything anymore. I mean, the rules were getting a little more complicated even before COVID. And in the last 18 months, as I'm sure you've heard through various media outlets, it's become extremely complicated. So you need to talk to an attorney no matter what you do, even if it's notices, whether it's just simple advice about little things around your properties. You need to contact an attorney it more than ever, because as I've warned a lot of people, even the longest veterans of housing providers have made some big mistakes with the ever-changing laws. Anything else to add on the fair notice, Rob?
No,
Yeah,
I believe that pretty much covered. You got anything to add to that, Rob?
of course I do. A couple things. For starters, keep in mind, everyone, that that's only in Chicago. And our clients have been issuing those notices throughout the pandemic. I don't think there was a stay on issuing those notices. So I have a lot of clients who issued non-renewal notices 5 months ago, 6 months ago. And as long as the tenant hasn't paid rent after that notice expired, we've been filing on those cases. So I don't think you have to give those notices now if you've already given those notices.
So, the next thing I kind of want to update people on this call are about is, I read one of the comments in the chat. I've got somebody who's been throwing COVID in my face for the last 2 years. I think there's been an assumption. I was at a party this week and somebody said, "Oh, you can't file evictions." Has that really been the case, Rob?
No, I've been filing cases the entire time. We took 2 months off in March and April of last year. But outside of that, our office never stopped filing evictions. I got pretty frustrated in the last couple months when people were saying I can't file cases based upon COVID. And that's frankly not true. We've been filing the entire time. The governor gave us some good carve outs in all of his executive orders. And once he included this declaration, we had clients serving declarations and then filing a 5-day. And if the tenant's not making any payments, we were challenging those declarations in court. For the first couple months of that, the judges were reluctant to allow you to move forward on evictions if they returned the declaration. But after a while, when the judges saw this every day of the same kind of nonsense and people paying zero, the judges allowed us to go forward on all those evictions, because under the declaration, rest in peace, our declaration, we can pour out some liquor for it. But it stated that the tenant was paying or doing their best to make timely partial payments. And if a tenant wasn't making any payments, we found that they were not covered. And the judges mostly agreed, outside of Lake County, where Judge Bitar was a little tougher on it. But we were moving forward on evictions this entire time. The sheriff was moving forward on evictions this entire time. You just need to know that the governor gave us carve outs, and you had to find out how to use those carve outs.
Yeah, absolutely. I echo all of that. I mean, there were carve outs pretty much other than those 2 months of shutdown. At first, it was just the emergency health safety threats. But then once the declaration process was introduced late last year, there were carve outs in there as well. There were certain situations where a judge did find that the declaration was valid. But as Rob said, in many of these situations, the tenant hadn't contacted the housing provider at all for anything for many, many months, despite repeated outreach by the housing provider. And so essentially the declaration form was in one way or another perjured on that point, because if the tenant hasn't even reached out, who hasn't bothered communicating in response, there's no way they could argue that they've been trying to make partial payments, that they've been communicating with the landlord about some kind of a payment plan. So the judges have been flexible. I mean, the judges have had a real tough time with this. They've been given a whole lot of new law that nobody has any guidance on. Really not even any guidance from the governor or anybody else who was issuing these orders. And the judges have done a stellar job in trying to balance everything to try to determine not only the intent of the law, but what it actually says on the practical application of it.
Yeah,
No, Mike, I think it was about a year.
They were not.
Mike, I think it was about a year.
So we were able to go forward. If someone returned a declaration, the judge just continued the case, ends on, months on end, but at least they were not dismissing the cases.
Right. I think the judges realized that if they started dismissing cases on that grounds, yeah, then you'd definitely be seeing a tsunami, an avalanche of a lot of cases that were being held up for that purpose alone.
So, Mike, I think it was about a year ago we were on one of these, and you had mentioned that the judges actually seem to be more sympathetic to the housing provider. They were kind of felt bad for us. Are we still seeing that disposition towards the housing provider and their situation?
I don't know if it's necessarily a sympathy, but I think there's a lot more clarity with the laws now. As these laws kept coming out, it was less a matter of sympathy than it was a matter of determining what is the point of this particular new order, or what does the Supreme Court order say? What does this require? So I don't think it's necessarily a matter of sympathy, but I think, as Rob said, at some point when the judges hear these cases, it's not that they're unsympathetic to the tenants and financial plights, but at the same time, I think they realize that housing providers, great and small, have bills to pay, and the vast majority of these rules are going to largely impact the small and mid-sized housing providers even more, and those are many of the cases that these judges see too. So I don't know if it was necessarily a sympathy, but definitely the judges started seeing a little bit more clarity in the law that was being provided by the various government entities.
Yeah, both you and Rob had brought up the declaration. Is the declaration still required at this point?
Me and Mike and the other attorneys are discussing this on a nearly everyday basis, and we've all kind of come down right now that the declaration is over, just like the Appendix A is over. Now that can
you explain the Appendix A for everybody?
Yeah. So first, let's just talk. You guys all know about the declaration. That's something that you had to serve before you issued any kind of notice of termination. Before you filed any eviction cases anywhere in Illinois, you had to attach the Appendix A. And that told the court that prior to filing, the case was either commercial, it was an emergency, or prior to filing, you issued the declaration and the tenant did not return it, or you wanted to challenge the declaration. So that was initiated by the Supreme Court. And as you all know, the moratorium ended a couple days ago. Now, things change quickly. So right now, there is no more declaration as we read it. There is no more Appendix A anymore. So we believe we're back where we were pre-pandemic. When you wanted to file an eviction case, you just had to file a copy of your notice, your lease, and the ledger if you had one, and you're good to go. Because this Appendix A slowed everything down and made everything a lot more complicated. But as of right now, knock on wood, we do not believe that you have to serve the declaration anymore or fill out that Appendix A.
And now, if I remember correctly, at the very beginning of this, there was the city of Chicago passed the ordinance where there was a 7-day negotiating period. That's in effect now, correct?
That is still out there with the COVID-19 ordinance. You have to attach that ordinance to every one of your notices when you serve them in Chicago. And
in Chicago, go ahead. Chicago has this COVID-19 protection ordinance. For your 5-day notices, basically, you've got to have a second page now that's on the city website. If you're not familiar with it, I'll send it out, the link out to the NBOA so they could send it out. But it's a second page that entitled Tenants Know Your Rights. It has to be served simultaneously with the 5-day notice if that's the route you're going. If the tenants do contact you at any point within the 5-day period, then you have to negotiate with them. Legally, it says that the tenant has to contact you in writing, which means text, email, anything in writing. What I've warned my clients is just to be safe, even if it's just a verbal statement, work with them for an extra 7 days, just so that there's no claim that you didn't try to do something or you didn't try to work in good faith with them about resolving the matter.
Mike, 2 things. One, keep in mind that they updated that notice, I think 24 hours ago.
It just came out a week or 2 ago, I saw.
So, and also, if you go to the website and the city, it says that if they tell you that they have a COVID issue, that you have to work with them and give them 2 months for every month that they owe rent. But ironically, that's not actually what the ordinance says. The ordinance is a lot less clear. So I think the city's website is trying to correct the boo-boo that the drafters of this ordinance did not include. But I'm not telling our clients that that's the law because I go by the ordinance, not what the city interprets it as. But I think it's important for all of our clients. If someone tells you that they have a COVID issue, and I don't know what that is anymore, but I'm not going to go there right now, you should work with the tenant about working out a payment agreement. them vacating or applying the security deposit to any monies that they owe you.
Right,
That's the requirement
exactly.
that's
The
not
ordinance
going
doesn't, right, the ordinance does not require you to come to an agreement. It requires you to work in good faith with them. But like Rob said, the website seems to try to suggest that you're required to come to some agreement. You're required to give them a particular deal. You're not required to do that. That you can't be forced into a contract. All the ordinance says is that you have to negotiate with them in good faith if they reach out about a COVID impact.
So Rob, now we've gone through, we've served a 5-day, we've exhausted the 7-day negotiating period, we've filed, and now we hit the ERP. Can you explain what ERP is?
The ERP is the early resolution program. 2 years ago, if we filed an eviction case and the tenant did not show up, we were done on the first court date. The judge would give us an eviction order and a judgment. Now, every time the cases are filed, the tenants get referred to the ERP, the early resolution program, and that hooks them up with a legal aid attorney to try to negotiate with the landlord. So every case now is continued for at least 14 days. And if no agreement was reached during that 14 days, then they assign it to a different courtroom to be set for a trial. So it used to be we file a case and we go to court, the tenant doesn't show up, case over. Now we go to court, it gets referred to ERP, we get a new court date 2 weeks out. If there's no settlement, they send it to another courtroom. And then on the next court date, that judge sets it for trial. So now there's at least 4 different court dates on routine matters. So this things got more complicated. They all got more expensive for no reason. And I don't think the ERP is going anywhere, so we all have to live with it. But it has driven the cost of evictions up pretty drastically because every case now has at least 3 or 4 court appearances.
Right, and the only break that the judges are giving on these, at least as of now, it's shifted a couple times. But for those first 2 court calls that Rob was talking about, is they're treating it more like a triage, where the judge isn't actually doing the trial. They're just talking to people, see if there was a resolution or see if the ERP administrators reached out to the attorneys for the housing provider. And basically, though, if the tenant does not show up the first date, it'll be continued. If the tenant doesn't show up the second date, the judge usually will give us a default order. That's been changing on and off. As of right now, I think they are giving a default order if the tenant doesn't show up to either of the first 2 court dates. But if they show up to one or both of the first 2 court dates, like Rob said, then we get kicked into another room for a minimum of at least another 2 court dates. So we're talking at least 3 to 4 court dates on every case.
So somebody is asking for the form for the 7-day. If you can throw that in the chat, someone, I much appreciate that. The question came in is, as far as the 7-day, does the tenant have to prove that they are impacted by COVID?
Not until we get in front of a judge, and even then, no, because it really doesn't change things anymore. It's not worth the time and the effort to try to prove that they are or are not. So it's not the same requirements as we had 2 weeks ago when they signed the declaration. So now if they say all they have to do is say I was affected, and then all you have to do is say, let's try to work it out. And then you both met your burden. The ERP is only in Chicago right now, but it's the judges are doing different things in different counties. But the tenant does not have to necessarily prove at this point that they're impacted by COVID, because them being impacted by COVID really doesn't change things right now.
And also along that line too, somebody had asked earlier in the chat about, does a health and safety matter expedite things anymore? Generally, no. I mean, specifically, it's not going to. But what I've had to do a couple times now, just in today and yesterday, is talk to the judges about a specific emergency as to why they should give us a shorter future date, and it's sort of worked. But no, I mean, now that there's no moratorium in effect, really nothing is going to speed up a case like it was in the last year and a half.
And really quick, if I could jump back to Emily, if she's still on. When we get into court and somebody is claiming a COVID impact, are they expedited or pushed into rental assistance? Emily, are you still out there?
Yeah, I'm still here. Yeah,
okay.
In Cook County, so in the state of Illinois, outside of Cook County, there is a sort of court-based rental assistance program that has a specific application procedure. Basically, the tenant can go through the Illinois Department of Human Services and the Illinois Housing Development Authority's program. Within Cook County and the city of Chicago have sort of set up an expedited process for folks to access rental assistance. It mostly goes through the ERP program right now, but they are building it out. So if folks are in court, there can be sort of an expedited process for accessing rental assistance. So you can sort of go on two parallel tracks there.
Thank you, Emily. And then, so back to Rob and Mike. So, you know, I'm not excited about the eviction being stretched out an extra 2 weeks to go into the ERP. But I found, and I don't know, it's interesting to me with the ERP, if you're finding what I found prior to the COVID and prior to this ERP putting in place, when I'm working with a tenant in the hallway, trying to come out with a resolution, if they're represented by an attorney or feel like they're properly represented, they seem to follow the agreed order more often than if they go pro se. Early on in this, are you finding that there are the residents are following their agreed orders that you've achieved through ERP, or are you? What are you seeing?
Not really. I'm seeing the same. I mean, tenants are tenants. I mean, some follow, some don't. I don't see a change. Mike, maybe you have, but I don't see a change if a tenant negotiates it on their own or if the attorney does.
No, not particularly. I mean, even the attorneys who represent a tenant, obviously they have no control whether the tenant's going to abide by the order or not. So I can say that the tenant's attorneys who've been reaching out on these have been at least very useful and expeditious in terms of trying to get a resolution. In most cases, they're just trying to get some kind of a move date, or if it's a matter of rental assistance, they're working with us on that as well. So I don't see a lot of, I would say maybe there are fewer delays being implemented. But other than that, no, I don't really see any kind of change, I don't think, in terms of how often the tenant actually abides by the order.
And what are we seeing as far as sealing of cases?
It's a nightmare. Hold on, before I get there, I'll say that once they open the courthouses, things are going to move a lot quicker. So we can actually be in the same room with the tenant and try to work it out like we used to, and hopefully avoid the ERP. Because once you get the parties to sit down, it's a lot easier to work a lot of these out. The sealing thing is a nightmare. It's a nightmare because there's no way of following up on your cases. There's no way of for a landlord to see if anyone's ever been evicted. And once the governor passed this rule, I'm getting tons of motions from old attorneys filing motions to seal court files going back years. And I stopped appearing on them because the judges just seal everything. It makes things a lot harder for everybody, but it's one of the rules that we have to live by, but it doesn't make too much sense for us.
It ends, I think it's March 22nd.
Can you explain what the order is a little bit? And for those who may not be really aware of it.
Oh, the sealing?
Yes.
Basically, earlier this year in May, the Illinois General Assembly passed a law that seals all cases, all eviction cases, residential cases, going back to March, I think it was March 9th of 2020, and it lasts all the way until, I believe it's March 22nd of next year. So many cases were sealed retroactively, and they're sealed upon filing. So, I mean, as soon as it's filed by the housing provider or their attorney, it's sealed. And so, like Rob said, it's impossible to see where anything is. The courthouse, and in some cases, even the judges sometimes can't see what's happened in cases. In a bizarre way, it's actually hurt a lot of the tenants and their attorneys because they can't see anything either. And I know I've spoken with a number of these attorneys through the ERP program who volunteer for the tenants, and they can't see anything in the background. They ask me to send something to them because they have no idea. They can't see any of the documents that have been filed in the case either. So it's really hamstrung a lot of people, just about everybody across the board. The bigger question is the General Assembly now going to go back next spring and try to extend it even more, again, under the auspices of COVID? I don't know. I wouldn't be surprised, though. Like I said, it expires March 22nd. That's right in the middle of the next General Assembly session.
So here we are. We've got about 8 minutes before the end of the hour. I'm going to try and wrap up on time. There are a few other questions in the chat. Syed Rahman wanted to know, can a judge direct a housing provider to take further assistance The court-based rental assistance program recently announced, and I don't know exactly what
No,
you
the
say.
judges don't get involved in that. They just try to move these cases. They can't order you to do anything
No,
necessarily.
they cannot order you to sign a contract.
And then we have a question here asking, is there anything from stopping previous landlords from screening tenants about evictions?
No,
No,
if you
the
get a
law makes
landlord referral,
that.
yeah, if you get a landlord calling you for a reference, you're allowed to say, I've evicted them. There's nothing wrong with that.
Okay.
And that's specifically in the statute. They made a specific carve out for that.
Okay.
And Mike, the statute
And-
lasts until August 2022.
Now, when we were about a year ago, we were expecting evictions to take a year, right? What are we expecting? Sitting here now, we haven't seen the tsunami as everybody expected. What are we expecting evictions to take all the way through the forcible?
From filing to actually having the sheriff come out on them, I'd say 5 months, maybe. Mike, what do you think? 5 months?
Yeah, I've been telling people minimum 3 to 4, but more likely 5.
Do we have to accept the assistance of every agency, or do the state, city, and county all work together differently? Actually, so the different ERAs, emergency rental assistance programs, are supposed to be talking to each other. So you should not be receiving a check from the county and the city, or IDA and the county, or any variation of them. You're supposed to be only receiving one check. There's supposed to be some communication in there. Is there, Mike, Rob, we'll start with Rob. Is there anything you want to kind of wrap up with, make sure everybody is aware of as we're moving?
Well, let me say this. I don't think there's ever going to be a tsunami of eviction filings. That's all just kind of progressive Twitter feed stuff. There's not going to be a tsunami because and if there was going to be a tsunami, I would have known about it because I'd have a ton of filings here. And we didn't, because we got rid of most of the people who were not paying at all, and their rental assistance helped a lot of people. I mean, obviously, when the government's cutting checks to landlords, we're never going to turn that away. But I think it did avoid a whole lot of evictions. It also got a lot of evictions settled. But the people who aren't paying you anything, you should be having those people in court the entire time. But we're not going to see a tsunami. We never were going to see a tsunami once again. And that's because the governor had a carve out for people who returned declarations and did not qualify. So that carve out avoided a giant wave of eviction filings. It's a process, but it's all doable.
Yeah, exactly. I agree. I don't think there's going to be an avalanche, tsunami, any other adjective you want to use for it. Very likely what's going to happen is the numbers are probably going to go back to even probably a little bit less than what they were pre-COVID, at least for a while. As Roman said from the outset, it's the last spot that any housing provider wants to be. It's the last spot any tenant wants to be. And it is a last resort. It was a last resort before COVID, and even more so now it is, because of all the delays and the expenses involved with it that are even greater, like Rob said earlier. So I don't think there's going to be a big avalanche of cases, but I do expect that the numbers will probably start to creep up toward the original amounts. But again, that may not happen until sometime next year.
Okay. And somebody in the chat asked for Mike to give his Michael Zink to give his email.
Sure.
I would also like to ask, if we've received emergency rental assistance, say to the end of August, and my tenant's now not paying September rent, what are we allowed to file the eviction right now?
Yes. It started, some applications were September 1, some were October 1. But if you received rental assistance and you couldn't go forward with the eviction, I suggest serving a new 5-day notice today, and you can file that case in 6 days.
Excellent.
Yep, absolutely.
Okay, so we've made it out under the wire of 1 hour. There's a lot of content. I want to thank all of our contributors today. I know that Becky jumped off, but love the fact that the sheriff is willing to spend some time with us, and Emily, always fantastic and fun, full of information. Michael, always great to see you. You always come in with a lot of great insight. And Rob, Haven't seen you in forever, but thank you for joining us and all your great insight as well. And if anybody wants to support the NBOA, you can definitely go to our website, nboachicago.com. We also have a way that you can make a financial contribution to the NBOA and everything that we've been doing to support the small housing provider. I almost feel like I'm on YouTube, hit like below and subscribe. I could do that. But once again, thank you, everybody, and have a great rest of the week.
Thanks, guys. Be